one of the counts of the offense where counsel
Verse C. Also pointed out that in count 2, the items that were allegedly destroyed as exhibits were not mentioned. At this moment, summary Wakoli for the prosecution moved court to amend the particulars in count 2 and 3 of the indictment, to which the defense had no objection. When the prosecution amended or altered the charges as granted by court, they included new charges against A2, A3, A4, and A5, whereby they added A4 and A5 on count 2 and added the A2 and A3 on count 3, to which the defense objected. The prosecution were purportedly proceeding under section 50 and 51 of the Trial and Indictments Act. The defense objected on the grounds that section 50 subsection 2 of the Trial and Indictments Act provides for an exception for the amendment under section 50 of the Trial and Indictment Act to the effect that no alteration shall be permitted by court to charge the accused person is with an offense which, in the opinion of the court, is not disclosed by the evidence set out in the summary of evidence. The defense also argued that it is misleading to say that you can amend charges at any time to include people who were never charged, that would be oblivious to the distaste of causing injustice or prejudice. That whatever is in the indictment for the people, for the other people, has nothing to do with the person who was not charged, and the committal for who were not charged and committed for trial, because they will not be bothered to prepare. They were not bothered to prepare their defense for a non-existing charge and facts which do not concern them. That you cannot just bring a person for trial who has not been committed for this session. Well, section 50 subsection 2 of the Trial and Indictments Act provides inter alia that the court may make such an order for the alteration of the indictment by way of its amendment or by substitution or addition of a new count as the court thinks necessary to meet the circumstances of the case, unless, having regard to the merits of the case, the required alteration cannot be made without injustice, and except that no alteration shall be permitted by the court to charge the accused person with an offense which, in the opinion of the court, is not disclosed by evidence set out in the summary of evidence prepared under section 168 of the Magistrates Courts Act what must be determined in this matter now is whether the alteration sought would lead to injustice to the accused persons, and whether the offences sought to be added are not disclosed by the evidence in the summary of evidence. In considering whether the alteration sought would not lead to injustice to the accused person, court examines whether the accused person shall be afforded the opportunity to defend themselves and the time allotted to the accused to prepare themselves also comes into play. In this case, it is at the beginning of the trial, and if the accused person is need time to prepare themselves, they can be afforded the time to do so. As for the consideration whether the evidence regarding the sentence, the said offences is disclosed in the summary of evidence, the prosecution stated that paragraphs 23 and 24 of the summary of the case include the said evidence. On perusal of the said paragraphs, court is of the opinion that indeed the said charges are disclosed within the summary of evidence. Consequently, it is hereby ordered that the indictments be altered by adding A4 and A5 to the said counts. That is the A4 and A5 to the second count, and adding A2 and A3 to the third count. Each of the said accused persons shall then plead to the charges accordingly. I so order. Uganda will be a bit more friendly because many people will follow. Can you say he understands Uganda? Because I read there in the chief master's code that he said he would use it. You ask him, which is okay. It is up to him.
Now.
Okay, then we shall continue. So you can explain. The summary of this matter is the court has decided that these people were seeking to add them, the four of them who are standing in there, the third and the fourth, that is Otai, and the Amanyiri on the second count, and then to add the other ones, I don't remember, but I will grab them in details. And then the others on the second count. It has been allowed, but they can be given time in case they need time to prepare themselves.